Hello class and welcome to part 3 of the libel and slander lesson series. So on this lesson we will tackle the defenses for libel. So I hope that you have watched part 1 and part 2 before watching this video. So as a recap, on part 1 we talked about the nature and jurisdiction of libel and slander, and on part 2 we talked about the 4 essential elements of libel. So on this lesson we will tackle the possible defenses in an action for libel. So how can you defend yourself for libel, or what claims can you say to defend yourself from libel, or in what instances or kinds of communication is libel not applicable? Let's start. So how can you defend yourself from a libel suit? So these are the possible defenses in an action for libel. The first one being privileged communication. The second one, fair comment or fair criticism. Number 3, apology or retraction. Number 4, proof of truth. And last one, self-defense. So one by one we will tackle these 5 defenses against a libel suit. So the first defense for libel is privileged communication. So as defined by the law, privileged communication are communication that are not actionable for any cases due to special circumstances. So there are two kinds of privileged communication. It can either be absolutely privileged or conditionally or qualifiedly privileged. So absolutely privileged communication, a communication is said to be absolutely privileged when it is not actionable, even if its author has acted in bad faith. This includes statements made by members of the Congress in the discharge of their functions, official communications made by public officers in the performance of their duties, statements, allegations from parties or their counsels during a judicial proceeding, provided these are relevant to the issues or pertinent to a question asked to witnesses. So basically, any communication made by members of Congress or any officials during privileged speeches or any communication in the exercise of their duties are completely protected against libel suits, even if there are imputations said in bad faith, because in privileged communication, malice in law does not exist. Another absolutely privileged communication are statements said during a proceeding by any of the people present, as long as they are relevant to the issues or relevant to the questions asked to witnesses. So, in absolute communication, there must be a valid occasion for a communication to be privileged. So, this could be during Senate hearings or privileged speeches, public communication by officials done in light of their duties, and during court hearings. So the freedom from liability is absolute regardless of the existence of express malice. So even if there is express malice or malice in fact, because the communication is absolutely privileged, then no libel suit can be filed against the one who did the privileged communication. For absolutely privileged communication, the only requisite is an occasion of privilege. So, the occasion is the only requisite for an absolute privileged communication to become non-actionable. There is only a need for a privileged occasion. So, as I said earlier, it can be during Senate hearings or privileged speeches, public communication, or court hearings. Next is the conditional or qualified privileged communication. So qualified privileged communications are those which, although containing defamatory imputations, would not be actionable unless made with malice in fact or bad faith. So unlike absolutely privileged communication, conditional or qualified communication may contain defamatory imputations as long as it is done in good faith or justifiable motives. So the freedom from liability is conditioned based on the existence or absence of malice. So if there is proven good intention, then malice is absent. This kind of privileged communication, the conditional or qualified privileged communication, becomes non-actionable against any cases such as libel. So, as requisites, there must be an occasion of privilege and the use of that occasion in good faith. So, another difference of conditional and absolute privilege communication is that there is a need for both an occasion of privilege and good faith for it to not be actionable in court. To further explain what is conditional privileged communication, here are examples stated in the Revised Penal Code. So, a private communication made by any person to another in the performance of any legal, moral, or social duty. Take note, private communication. Next is a fair and true report made in good faith without any comments or remarks of any judicial, legislative, or other official proceedings which are not of confidential nature, or of any statement, report, or speech delivered in said proceedings, or of any other act performed by public officers in the exercise of their functions. The next defense for libel is fair comment or fair criticism. So on fair comment, there is a doctrine which is called the doctrine of fair comment. So a comment which is true or which, if false, express the real opinion of the author. Such opinion having been formed with a degree of care and on reasonable grounds is considered fair. So according to Borjal versus Court of Appeals, in the ruling, if a comment is an expression of opinion based on established facts, then it is immaterial that the opinion happens to be mistaken, as long as it may be inferred from the facts. So basically, the doctrine of fair comment means that if the opinion is made based on facts, then it is considered fair comment. This is not actionable because fair comment constitutes to justifiable motive. Another one is the privilege of fair criticism. So, fair criticism supposes that everyone is entitled to his own opinion on matters of public interest, but it must not be expedient to allow false and unfounded allegation of facts. So, according to U.S. versus Sedano, the interests of society require that immunity should be granted to the discussion of public affairs, and that all acts and matters of a public nature may be freely published with fitting comments and strictures. So, fair criticism allows that the public to talk or express their views on matters of public interest, but it still must be based on facts and not false allegations for it to not be actionable for libel. The next defense for libel is apology or retraction. So this is often done by media outlets that may have let a few false information broadcast or printed. So they make an apology or a retraction to make up for what is already done. So an apology or retraction, a retraction published to correct the mistake, does not wipe out the responsibility arising from the publication of the libelous photograph or article, although it may and should mitigate it. The retraction should contain an admission of incorrectness or the falsity of the libelous publication and evince a desire to repair the wrong or harm done. So basically, this is making things right when you have already published or broadcasted something that is libelous or false in nature. Um, this can be done. This is done often by media outlets, as I've said earlier. So the consequence here is if the plaintiff or the offended party agrees to the publication of the retraction and declares that it satisfies their claims, then the plaintiff cannot put forward any action for damages. So wala siya compensation madawat na unless he or she pushes the moral damages in court despite the retraction, which is entirely up to the offended party. Next defense for libel is proof of truth. So this is basically one way to get yourself out of a libel case. And this is to defend that what you said was the truth, or you were merely saying the truth. So you present proof of truth. But take note of these instances where proof of truth is admissible. So, according to Article 361 of the RPC, when the act or omission imputed constitute a crime, regardless of whether the offended party is a private individual or a public officer. So, kung napatunayan nimo na ang crime na gibuhat or giingon nimo sa imong statement is truth, then you are acquitted from libel. Another is when the offended party is a government employee, even if the act or omission does not constitute a crime, provided it is related to the discharge of his official duties, but when the imputation involves the private life of a government employee, which is not related to the discharge of his official functions, the offender cannot prove the truth thereof. So this means na kung ang remark na imuhang giingon about a government employee is truthful and is based on their duties, then ma-acquit ka from libel. But if you said something about their personal life, even if it be true, the case will still proceed to prove if you said the imputation with good faith or justifiable motive. So in proof of truth, when it appears that the matter charged as libelous is true, and it was with good motives and justifiable ends, the defendant is acquitted. So once again, if you can prove that you are only being truthful and you did it in good faith, then you will win against a libel case filed against you. The last defense for libel is self-defense, or to justify one's hitting back with another libel, there must be a showing that he was libeled. So self-defense is basically creating a reply of something libelous that was published about you. So, in the concept of self-defense, if one's good name is assailed in a newspaper, he may reply defending himself, and if his reply is made in good faith, without malice, and is not necessarily defamatory of his assailant, then it is privileged. So it is protected. As long as it is self-defense and he did it in good faith and he used correct words. Okay? So further in self-defense, while a person may be legally justified in defending himself or his near relatives against libelous articles, nevertheless he may not use offensive language against the libeler. He cannot make against his libeler a counterattack that contains libelous statements, but if he does, then he has exceeded his privilege and the law shall give him no protection. So if he was not being careful and exceeded the means of self-defense and came out as lashing or doing the same evil that was done to him, then the law will offer him no protection. He can have the tables turned around him because of this and find himself with a libel case rather than a ruling against his libeler. So, murag gibalik ra pud niya ang libel case sa iya if he does this. So if you will do self-defense, make sure that you are being truthful. You say it in an careful language, and you say it that you prove it that it is not malicious, and you do it in good faith. Okay. And that ends our lesson series for libel and slander. This is the end of part 3 of 3, and I hope that I have aided you on your self-directed learning all throughout this complex area of media law, such as libel and slander. So, stay safe, class. Thank you for listening, and see you as soon as the world heals. Thank you, and God bless.